Your Honor, may I proceed?
You may.
Thank you very much. May it please the court, Madam Court Reporter, Adam, Ms. Stevens, Mr. Pearson, Ms. Amlin. Good afternoon, ladies and gentlemen of the jury. Good afternoon. I'd like to thank you as well, a little bit different thank you. You stood up in the beginning of this process when the judge swore you in, and you took an oath not to form any conclusions or form any opinions until you heard all the evidence, until you've seen all the evidence, all the arguments, and the judge's instructions. Now, as you know, we've been a bit busy, but we've tried to watch you, and I do believe you've kept that oath. And for that, I thank you, because without you keeping that oath and performing your civic duty, we wouldn't have the best criminal justice system in the world. I thank you for that, and I appreciate it. Closing arguments. Put the government's case to the test, show you what our case is about, ask the tough questions. We now know what the government's theory, that somehow he shot an unarmed man and made the entire thing up after the fact. Okay. That's perverse, ladies and gentlemen. That's desperate, ladies and gentlemen. That's the government, ladies and gentlemen. Ms. Stevens told you in the opening that the theme of this case is one of reasonableness, one of justification, all right? One of a mistake was made and whether or not that mistake was reasonable. That's what this case is about, ladies and gentlemen. I'm going to do my little chart again that you saw in openings. I'm going to leave that up there. Can everybody see that okay? So this case is about the situational need to use deadly force, not for an unknown reason, not for something that's kept secret, because he saw a deadly threat. He perceived a deadly threat. So this case is a bit different, but it's very simple, ladies and gentlemen. It's very simple. It's a different analysis because first, as the chart says, you have to analyze whether or not the state proved beyond a reasonable doubt each and every element. Specifically, what did we tell you in opening, in voir dire? Mental elements, okay? No one's challenging the date, the time, the county of Franklin, it was Mr. Hill, it was Mr. Coy. Those are the other elements that they must prove. The only thing that we're challenging that the state did not prove beyond a reasonable doubt, proof of such nature to rely upon it in the most important of your own affairs, surgery for a loved one, care for a child. Okay, the mental elements. Recklessness. They have to prove recklessness beyond a reasonable doubt. At what point in this trial did you hear the term reckless ever used by any of the witnesses by the government, including Seth Stoughton? At what point, ladies and gentlemen, was there any evidence that our client was reckless? Recklessness, the mental element, is a heedless indifference, disregarding a known risk. Okay, disregarding a known risk. There's no evidence of that. They haven't provided that. Recklessness, ladies and gentlemen, is different than knowingly. They've put two theories of the case up on a board because they don't believe in their own case. Knowingly standard is a different component than recklessness. I'd submit you can't have both at the same time, ladies and gentlemen. When he decides to pull that trigger, you can't have recklessness and knowingly at the same time. They're competing. Now, what he didn't tell you just then about the mental elements, because he didn't go into them, is that at the time my client fired, what was his intent? The next step is everyone who testified from the Columbus Police Department, the two experts, what are they trained to do? I asked every one of them. Are they trained to injure? No. Are they trained to kill? No. They're trained to stop the threat. If they fire once and miss and the threat stops, that's what they're trained to do, to stop the threat. They don't form the intent to cause serious physical injury with that. Mr. Pearson just said, oh, yeah, I'm not asking them to shoot a limb or something like that. That's exactly what he's saying. They don't form that intent when they fire their weapon. That's not what they're trained to do. They don't form a reckless intent when they fire the weapon. They're trained to react to a deadly threat, and that's the only time you can, ladies and gentlemen. A perceived deadly threat. What known risk was put out there by the government in its case in chief? There is none. Zero. Throw both up there. Hope you guys will compromise and go to that. Look at their witnesses. Their own witnesses show that it wasn't reckless, or that it wasn't that it wasn't knowingly. Why? Officer Detweiler. What did Officer Detweiler tell you? I said, had you perceived the same threat, what would you have done? She said, I would have shot. I would have shot. She couldn't see that side of the body. That's why she didn't shoot. Had you seen that? Everything about Officer Detweiler, was there anything reckless about her testimony? Was there anything reckless that she did in that situation? Because she said, I would have done the exact same thing. Did you believe Adam Coy thought, an honest belief that he had a silver revolver in his hands? Absolutely, she said, 100%. Now, don't just listen to her word. What about Officer Brantford? Police tactics. Officer Brantford, remember, was sent out on a robbery run, lights and sirens, right? He's heading up there. It turns out it was a domestic disturbance, something a lot lower. What do I ask him? Hey, had you been encountered someone who presented a deadly threat to you, would you have fired? He said, absolutely. That's what we're trained to do, to stop the threat, not to injure. And there's nothing reckless about what he said as well, ladies and gentlemen. That's their witnesses. Now, ladies and gentlemen, if they don't prove their case and it's a no beyond a reasonable doubt, you stop there. It's not guilty. Right? We all agree on that. All right? If for some reason we don't concede that you do believe that they prove their case beyond a reasonable doubt for the mental elements, then you have to examine our burden, okay? Our burden. Whether or not we proved justification beyond a preponderance. And again, how about Mr. Stoughton? Beyond a preponderance, he acted like he'd never heard the term before, and he's a lawyer, and he teaches law students. More likely than not, ladies and gentlemen, he didn't know that that's the standard in Ohio to judge a mistake. That's why he told you, oh, gee, more likely than not, oh, geez, I've never heard it that way. Because he doesn't know the law in Ohio. One smidge over 50, it's not 51%, it's more likely than not a tipping of the scales, ladies and gentlemen. And please hold us to that standard if that's where you are in your analysis. We have to prove two things. More likely than not, that Adam Coy had a subjective belief that he was in imminent fear of serious bodily harm and injury. Okay? It's not afraid of the situation, ladies and gentlemen. It's an imminent fear of receiving bodily harm or serious physical harm or deadly threat. That's what the fear is. And you heard Kevin Davis say there is no greater fear than someone leveling what's perceived to be a weapon at an officer. And the best part about the government's rebuttal case is no matter how Mr. Stoughton defines threat, ability, opportunity, intent, you won't find that in the jury instructions, ladies and gentlemen. You won't find it. That's why Mr. Scanlon and Mr. Davis said, do you agree with his report or not? Well, I agree with parts, but not parts, because he makes up his own standard. He makes up his own definitions, because he's got to create that in order to start from a premise and work backwards. The second thing now that we have to prove is more likely than not was the decision to use deadly force reasonable based on the totality of the circumstances from a reasonable officer at the scene in his or her shoes, experiencing what they perceive, not what could have, should have, would have done with hindsight of 2020, but could have believed the need. That's the issue that you examine more likely than not. All right, let's go through and let's talk about our burden, okay? Let's look at the first prong. The first prong we have to prove, more likely than not, that Adam believed he was about to be shot at. Okay, it's that simple. All right? We have proven that more likely than not, ladies and gentlemen. How? He had a subjective belief because he told you. He told you he believed and perceived a gun was coming, okay? So that's one way we prove it. How is that corroborated? He announced it. He announced, gun, he's got a gun. No matter how much they want to say he made up a story, he announces it and Amy Detweiler hears it before the shots. Do you honestly announce something if you don't perceive it? So was he actually lying from that part as well, knowing that he was going to shoot an unarmed man and announce gun, gun? That's how preposterous their theory is. He tells you what he sees, he announces it. We have proven more likely than not he had a subjective belief that he was in danger of serious bodily injury or death. That's the first part, his belief. All right, second part, all right? Now, the second part is bigger. It's bigger than what Mr. Pearson made it out to be. It's bigger because it contains multiple things about reasonableness, okay? So, we know in hindsight that there was no weapon, correct? We all agree. We know in hindsight there was no weapon. So now we have to look at the totality of the circumstances. You have to put yourself in Adam's shoes and determine whether or not the mistake is more likely than not reasonable. Now we'll go over the police terms for that, but just using your common sense, when you put yourself in those shoes, was it reasonable using your common sense? It's pitch black out. You can't see in that garage. You see the body-worn camera, how dark it is, okay? There is no light on. It's almost 2 a.m. Close confines. Not a lot of room from the car to the other side. Duty to investigate. No matter what Mr. Stoughton says about a person in a garage that they don't have the ability to investigate, every single police officer told you that they had a reasonable suspicion to investigate in that situation. You can't see the full body. There were commands given. There was partial compliance. There was a left hand up, not the right hand. There was blading, and I'll get to the body-worn camera, ladies and gentlemen, but remember, the body-worn camera only had a certain amount of look back. Adam and both Officer Detweiler described for you many events that happened in the back of the garage that aren't on the body-worn camera, okay? That aren't on the body-worn camera. And I'll get into that of what a camera sees versus a human eye sees. Using your common sense, bladed, okay? Did at any time prior to this, to Mr. Hill coming to the car, did my client pull his weapon out? No. At any time when he said, hey, where you going? Come back here. Did he pull his weapon out and draw down on him? No. He wasn't reckless. He was reasonable those times. And an entire interaction. Once he sees, ladies and gentlemen, the glint of steel, that's a term because it's a Supreme Court term. And Mr. Professor's like, oh yeah, I think it's in one of those cases. You don't have to wait to see the glint of the steel. My client saw the glint of the steel and reacted, ladies and gentlemen, reasonably. Was the mistake reasonable? Use your common sense. Ms. Allen, may I trouble you for the keys? What else using your common sense? Government doesn't show you these keys, ladies and gentlemen. They don't show them to you. When you untangle them, we had them measure 8.5 inches. We had them plumped and stuff like that. Okay? Common sense. Just using your common sense. Do you think these could be mistaken in the hand of a person as the hand comes up? We can't tell you how they were being held. We can't tell you if it was a clump. We can't tell you if this was there. Okay? But is that a reasonable mistake based on these keys? If they were all black, of course not. If there was no metal or silver, of course not. Okay? And remember, they're missing 2 things here that were given back. Using your common sense, ladies and gentlemen, is the mistake reasonable? Their own expert admitted, well, yeah, in hindsight, he had the keys in his hands. Okay. They're silver, they're metal, regardless, compare that to the picture of the revolver I told you. We talked about this in voir dire, the difference between a semi-automatic, shotguns, and revolvers. I showed you a picture of a silver revolver. Most of it's silver, and about the same length, depending. And what did Adam describe? I saw a short thing with a bigger thing in the back. That's what he described. Is it more likely than not a reasonable mistake? Now, if he said, oh yeah, he had a black semi-automatic in his hand, or he had a gun in his, a semi-automatic in his hand, or he had an Uzi, or he had an AK, or so, of course that wouldn't be reasonable, ladies and gentlemen. Of course not. Here's the best thing. What have they shown that it's not reasonable? How is the mistake not reasonable, ladies and gentlemen? We've shown way beyond a preponderance, more likely than not, that the mistake was reasonable based on based on his statement, based on gun, okay? Based on Officer Detweiler saying, absolutely, I would have shot had I seen that. We have proven more likely than not. What else, though, ladies and gentlemen? His belief that he had a gun. And again, this screws up the state's theory that he made it all up after the fact. What else? Because he says, get back to Officer Detweiler. I can't see his hands. He's still got a gun. Find the gun. Why do you tell somebody that if you don't believe there's a gun in his hand? You don't. You don't yell gun, and you don't tell someone, hey, wait a minute, get back. Now, that's not just his statement on the stand. That's Amy Detweiler's remembering and perception. And it's backed up by the body camera. You hear it, and so you get back. Don't get him until that. Those are all corroboration that Adam's belief that he had a silver revolver in his hand, ladies and gentlemen. And yes, he's mistaken about it. And that's the hard part. We're asking you as a jury, the hard thing to do when there's no weapon, that there was no weapon in hindsight. So remember we talked to voir dire, we ask you to be a clinician. That's a hard thing to find that someone made a reasonable mistake when there's no gun. If there was no anything there, okay, they got an argument. If there's nothing there, their own expert says, hindsight, he had keys in his hand. We know the keys are there. Ladies and gentlemen, the judge will tell you the objectively reasonable officer can be mistaken, even if he had a mistaken belief. As long as that mistaken belief is reasonable and none of the then existent circumstances, the officer is justified in using deadly force. If an officer reasonably but mistakenly believed the individual posed a deadly threat, the officer would be justified in using deadly force. So I'm not sure what he doesn't understand or what's hiding or something like that. It's been no hiding that our client did a voluntary written statement, a voluntary interview. He testified in front of a family, in front of the people, in front of 15 strangers about what he went through. And they don't believe it's reasonable? Now, there's other things that the judge will tell you, like Ms. Stevens said in the opening. The judge is going to tell you that actual possession of a weapon is not relevant, as long as the officer reasonably believed the individual possessed a weapon. The law does not require officers to wait until an individual uses harm or starts to use harm or confirm that a serious threat of harm exists. There is no checklist to say, oh, I got to wait a certain amount. I got to wait to see if there's just an actual serious threat. No, that's not how they're trained. That's not how they're trained. Because as a society, we don't want them to make mistakes because we know that a mistake can be deadly and tragic, just as this case is. We know that, but we put officers in impossible situations. We put that family in an impossible situation to tell them about justification. And we put you guys in a difficult situation because there is no weapon there. It was a mistake whether or not the perceived deadly threat was reasonable, whether or not the mistake was reasonable, ladies and gentlemen. That's exactly what we have here, what the judge will read to you. So Mr. Stoughton and his creations, those are distractions. And I understand, ladies and gentlemen, it's a tough law to follow. We talked about that in voir dire. It's a tough law to follow, okay? But that's the task that you have, and we all trust that you can do it and follow the law. Moving on to the second prong of justification. Second one, remember, decision to use deadly force was reasonable, given the totality of the circumstances based on the eyes of a reasonable police officer on the scene. And you're going to hear that over and over again in the instructions. So I'll get right to it. Is it more likely than not that his force was reasonable? The state put up two witnesses that both confirmed that. The first, Amy Detweiler, how she was trained, the stuff that she goes through, the shoot, don't shoots, the train to stop the threat, actions faster than reaction, you don't have to wait. All of those we went through with both Officer Detweiler and Branford, their witnesses. And both of them said if they perceived a deadly threat, they would fire. That's their witnesses, ladies and gentlemen. I hope you believe that Mr. Branford or Officer Branford and Detweiler were credible. How credible was Officer Detweiler when I went to show her the picture of the keys? What'd she say? She goes, I don't recognize those. Okay. She's not going to talk about them because she doesn't recognize the picture. Okay, and that was our part. That's someone who's telling the truth and who's credible. And what did she tell you, ladies and gentlemen? She told you that enough. They talk about this lack of communication. Amy Detweiler gets out and goes, 10-4, meaning, no. She had seen the person walk away. Nothing's making sense. Something's weird. What does she do? What does Amy Detweiler do at that instant? She pulls out her gun and gets it low and ready. That's based on her training and experience, ladies and gentlemen. But Seth's out and have you think, oh, no, it's okay. Someone wandering around a dark garage. Oh, no, that's all right. Why did, the most credible thing Amy Detweiler said was, I asked her this, why didn't you shoot? Sir, we're trained if we don't see a perceived threat, we don't shoot. What could you see? I couldn't see the right side. I asked her how she felt about the cell phone. She goes, I felt like a fool because I fell for the distraction. They're trained not to. They're trained to keep looking at different things. She goes, I felt like a fool. That's someone who's credible. That's someone who's reasonable. She didn't see the right hand. She's not going to tell you unless she's sure, ladies and gentlemen. Well, what was she sure about? She was sure that Adam Coy believed he saw a silver revolver because he announced it, gun, and he told her, don't go up there. Branford, again, on a robbery call. And I asked him, if someone presented what you believed was a silver revolver, even though on the robbery call was something else, he would shoot. That's reasonable. Those are their witnesses, ladies and gentlemen. We provided you two witnesses, and I'll get to the witnesses more, who went over that. These experts, ladies and gentlemen, that we presented you, train officers. Their expert trains law students, okay? They all indicate that if you perceive a deadly threat, even the government's expert says, if you perceive a deadly threat, the use is consistent, the use of deadly force in response is conditioned with national policing practices. Now, the state wants you to focus on a singular thing, ladies and gentlemen. What I mean by that is they want to take everything out of context. Well, he didn't use vulgar language with you, right? Or he didn't have to do this, meaning Mr. Hiller have to do that. So let's talk about all these ambiguities that Mr. Stoughton goes through. And an important thing here, ladies and gentlemen, is the timing. What time is he sent out on the run? Like 1:30. Says he gets out there in 5 or so minutes, okay? What time does he run the tag? 1:45. So he's been on the scene, we know at least probably 10 minutes. What time is it aired shots fired? It's like 2:02. So from 1:35, ladies and gentlemen, 25 minutes puts you at 2 just after, okay? That's 27 minutes that our client encountered Mr. Hill and observed things. The end was very fast, yes, but keep that in the back of your mind, the time issue here. Now, I'm going to walk you through from the time he got dispatched all the way to the use of force, okay? And you tell me, ladies and gentlemen, you ask yourself, is this odd? Is this different? Would I want this type of police officer investigating? Is this reasonable? Ladies and gentlemen, he goes to a silver SUV. Turns out to be the wrong one. So is he mistaken about that? Yes. Thank goodness Mr. Renker calls out. Says, hey, it's not there, okay? That's odd. It was here. Well, it moved. Okay. They go into the catalog. And Mr. Renker, what does he talk about? On the 911, hey, I'm not going out there. I don't have a gun. I'm afraid. I'm not going out there. It's all about what perspective you're coming from, ladies and gentlemen. So you have to put the totality of the circumstances. So, okay, no big deal. I got this. Go inside, he tells him, and he pulls up there. He doesn't pull up there in a half-ass reckless way. He pulls up there just as he's trained to do, offset behind. He approaches a vehicle that he's done thousands and thousands of times over his 18 years of service, ladies and gentlemen. And as he goes up, he stopped because the gentleman, Mr. Hill, turns around to show him something. We asked, did that seem odd? Well, yeah, normally, Mr. Pearson asked him that. And he said, yeah, normally they don't say anything until I get to the window and I have to knock on the window. Okay, anything wrong about that? Anything suspicious? No, ladies and gentlemen. So, hey, she'll be right out. He notices white-eyed jittery. He's cataloging it. That's what Mr. Scanlon told you. You catalog these things. That's what they're trained to do. No singular incident here, ladies and gentlemen, in and of itself allows the use of justifiable deadly force, except when you get to the raising of the arm. But it's the ability to investigate, ladies and gentlemen, the reasonable suspicion. Okay, go right ahead. As he walks by the car, he sees there's a bunch of stuff in there. He sees that it's tinted. And so he goes in his car and decides the weight. Gee, I don't know, using your common sense, is that probably a good thing to do? To see if the person comes out? Yeah. Okay, he can't just take off. He's there on a run. He has a duty to investigate. So at that point in time, he runs the tag. Now, they make a thing out of it that, geez, he didn't ask his name and he didn't get his ID. There was no need to. He was doing nothing wrong. Yeah, hey, good, you're good. And what did Mr. Coy tell you? And you know, he told him why I was there. Hey, I was here because I was dispatched on a vehicle. Yeah, I'll wait till she comes out, or I'll wait till the person comes out, right? So then the situation is, okay, nothing happens. Nothing happens. How long does it wait? We know he runs a tag at 1:45. Then all of a sudden, the individual Mr. Hill gets out of his car, goes in front of him. What does Adam do? He's not eating his lunch in the cruiser, not paying attention. He gets out and stands up as he's trained to do. He watches him. Now, is it odd that he doesn't go to 1070? He's parked on the furthest edge of 1070. Sure, it's odd. Sure, it goes into the calculation. Is it odd that he doesn't walk up the driveway to 1070? No, he comes and goes like this. Adam follows him. And he comes across and goes up. Okay. Has he done anything wrong or illegal? No. But it catalogs it. It keeps building, ladies and gentlemen. When you go through the event, all right, geez, it was at 10:54 hours maybe, you know, he's told. Then it goes to 10:70. Does this person belong here or not? Okay, so the guy's gonna knock on the door. If you're waiting for someone, is it common sense to believe that someone will answer the door? Or that someone will turn on a light or anything at 2 in the morning if you're waiting for them? Of course it is. So does it make sense that no one does? No. And you have to put that in your mind. And he doesn't just do it once, he does it twice, loud. Mr. Pearson doesn't tell you that in his closing. He skips right to the garage. Twice, ladies and gentlemen, and no matter how much he gets paid an hour, $3.20 or whatever an hour, with regards to knocking on the garage door, Mr. Stoughton watching on this door, or whether or not it's a typo. I mean, ladies and gentlemen, for real? Okay, so then what happens? He comes back. Common sense. Adam Coy being reckless at this point, doing anything? No. Common sense, hey, what's going on? Nothing. The guy goes, opens the car door, rustles around and grabs something. Officers are trained that that's an opportunity to retrieve something. They have to think in advance. They have to expect the unexpected. Is that an opportunity where someone might have grabbed a gun? Is that an opportunity where someone might have grabbed a weapon? Of course they had the opportunity, even on Mr. Stoughton's scale. Definitely could have gotten one there. Now, they're not saying he's doing that. But that goes in their mind because that's how they're trained, ladies and gentlemen. Then he comes by, goes, hey, what's going on? The guy just keeps walking. And then as he gets by him again, the gentleman keeps turning back. What are those? Those are targeting glances. He wants to know where my client is. Again, you're not to consider the intent of Mr. Hill. That doesn't go in the equation. But the officer has to observe the body language. The officer has to observe the glances. They're trained that that's a potential threat indicator. That could be a danger cue. Call it what you want. That's good policing. That's not reckless. That's doing your job. Then what happens, ladies and gentlemen? He loses sight of him. As he loses sight of him, Detweiler pulls up. Okay, we now know when Detweiler gets out 10-4, we've gone over that. Detweiler, something's not making sense. It's weird. The years they've worked together. You heard Adam talk about a different burglary he did a month earlier. We walked into a house and the stuff's going, and people are tied up. So, ladies and gentlemen, something's not making sense. We have a duty to investigate at that point in time. Amy Detweiler testified she had a reasonable suspicion at that point in time that a trespass was going on because she saw the going like this or something else was going on. And if she has a reasonable suspicion, Adam Coy has a reasonable suspicion, no matter what Mr. Stoutland's claims. So at that point in time, they have to investigate. They don't get on the speaker and say, hey, we're about to walk up this driveway. Announcing it to everyone. That radio goes to everyone on the force. We'll let you know what happens. Check back in or get on the speaker in the car. That's not how they're trained. I don't know how Mr. Stoutland was trained. Stoutland was trained in Tallahassee, but that's not how they were trained here in Ohio and in Columbus. So then what happens? They approach, tactfully they approach. Amy Detler to the right, backing offset, Adam Coy to the left, right? They tactfully go through it like they're supposed to. What's Adam tell you? His intent is at that time. He believes the person went around back. So his intent is to go around back and find out what's going on, make contact, ask questions. What does he see? He sees a dark garage. At 2 a.m., a garage door opened in the middle of the winter, 3 days before Christmas. And it's dark, and there's no light on there, and it's open. Okay, now we gotta check this garage. That's what he's doing. He's investigating. And ladies and gentlemen, the definition of a burglary includes a garage. And then when he comes around, he sees the shotgun, he tells you, he's crouched down in the way back of the garage. The way back. Is that consistent with, hey, potentially something might be going wrong? Of course it is, ladies and gentlemen. Of course it is. That Detweiler's got her gun out low and ready. That's how seriously she takes it. Adam doesn't even have his gun out at this point, ladies and gentlemen. As he's approaching, he's got the flashlight out as he's approaching. Hey, come out here, show yourself, show your house. What you won't see on the video is that the boss said he was facing that wall. Okay, he turned. Come out here, show yourself. Something's not making sense. He doesn't come out at first. And then he comes out, not fast, not slow, but they're both watching from different angles. And what does Adam tell you? I see him get closer to the car. It's a tight confines when you look in there. I see him turn towards us. What's that? Ladies and gentlemen, that's a cue. Waiting, whatever. Now, it may not be the part on the video that's there, but that's what he sees. And guess who else sees it? Amy Detweiler. She's coming up from straight ahead. And she says, yeah, I'm walking up straight ahead. And then I see the thing, but I see him turn. I can't see his right side. She has more of a straight angle at him than that. So in order for their theory to be correct, that he made this up after the fact, that means Amy Detweiler's in on this conspiracy. That means Amy Detweiler should be charged with accomplice to murder. And she's not, because it's a ridiculous theory. Because if you yell gun, gun, then Amy Detweiler's got to be in on it. Gun, gun, gun. If you say, hey, he's bladed this way and I can't see him, that means Amy Detweiler has to say, oh, I was on this side, but I couldn't see his right side. That means she's in on it. And the worst thing, ladies and gentlemen, would you ever turn your body camera on if you lied about this from the go? No. The government says Adam Coy, a Marine, or excuse me, an Army, 5 years honorable discharge, giving service to his country, a family person who has given his life to this community, made it up and lied, and somehow got Amy Detweiler in on it too. That's what has to happen if you believe their theory of why he shot, that he created the lie after the fact. What did Jim Scanlon say about the garage? There's a guy with common sense, right? Hey, do you want someone to investigate if you found out that your garage door was open and it was 2 in the morning and it was dark and someone was in there? Of course you all would. That's what we ask of the officers to do. But somehow that's reckless to the government. Somehow that's not doing your job. I don't care what's going on out there. Every single officer testified that an action beats reaction. Do you honestly want to base this case on a game that you used to play as a kid with hands here and hands here? Let's just look at that on his testimony. If you're playing that game with me, your hands are on top of me, right? You know that I'm going to try to hit your hands. You know that in advance. So you can anticipate moving yours. Right? If you guess right or anticipate right, it might happen. An officer doesn't know when a gun is going to be leveled at him or her. An officer doesn't get that warning. Hey, let's play this game. I'm going to do this, and then you tell me when you might. Are you going to draw a gun or not? No. That's how ridiculous his testimony is. A childhood game that you know an action's coming, but yet that's why he has to qualify an action. It's not really sometimes faster than reaction. Use your common sense, ladies and gentlemen. Don't be distracted by that argument. Take your common sense back there with you to the jury room. Look at the jury instructions, ladies and gentlemen. Did you hear Mr. Stoughton say one thing about Graham v. Connor reasonableness factors? No, because he doesn't use them. You'll see in their terms whether or not the individual attempts to evade an officer. I don't know, is it more likely than not that when he walked away and he didn't answer, he was attempting to evade him? Could a reasonable officer believe that in this situation? It happened, ladies and gentlemen. It happened, and he went into the back of a dark garage into a corner. Furtive glances, sudden turns, or justice. We have that here. Again, you can't make this up, ladies and gentlemen. This is the law of the Supreme Court. Ignoring commands. Yeah, hey, what's going on? Hey, what's going on? He's ignored. Partial commands, show yourself. There's a big thing here about show yourself, your whole body, come out. He had the left hand up, put the right hand up. It happened during investigation. You'll see that in there. The possibility that the suspect may be armed. You have to consider that. You have to consider that when he rummaged through the car. It goes through the equation. That's why they ask you to do it. The severity of crime at issue. Kevin Davis told you there's no more severe crime than someone pointing a weapon at an officer. Whether the suspect posed an immediate threat. An immediate threat. Now, it's not Seth Stoughton's definition of what an immediate threat is. You won't see that in the jury instructions. What you'll see is an immediate threat. Use your common sense. All of you have common sense. Immediate means immediate. You don't wait. And you'll have a jury instruction back there that if you believe by one witness, so one witness, Adam Coy, if you believe him more likely than not that it was a immediate threat and it was a reasonable mistake, your verdict must be not guilty. Now, we talked in voir dire, ladies and gentlemen, about cooperation, okay? And stuff of that nature, a smidge over 50%, more likely than not. We have proven to you, ladies and gentlemen, it's more likely than not reasonable based on totality of the circumstances without using hindsight 2020 and within the eyes of a reasonable police officer. Now, I don't get to argue again after this, even though we have a burden here. I don't get to argue twice. So I have to try to anticipate what they're going to argue after this. So I anticipate that they're going to attack Adam Coy's credibility, because they tried to on the stand. Okay? And what was that? They asked Mr. Davis, Kevin Davis, hey, if there was something different in his statement and his interview than he testifies on the stand, would you change your opinion? Oh, I don't know. You'd have to tell me what that is, right? I don't know. Right? So you can't change your opinion or address the opinion unless you know what the inconsistencies are, okay? So when Adam Coy testified, he testified that the first one, with reading the quotes. In his written statement, he said, yeah, put the quotes out there, something to that effect. I saw something to that effect. I'll be right out. I saw that stuff. Same in his tape statement. On the stand, he says, I could see the text bubbles. He told me he was coming out, and he said he told me she was coming out in his first statements, but I can't see it. I can't see that far. And then we go into the whole contact things and faraway things. The concept he was explaining when he was allowed to, it's exactly what he said. That's their inconsistency, is that in a statement, a 10-page written statement and a couple-hour interview, the only inconsistency is that, oh, he said this, read the text, but on the stand he said he just could see the bubbles. Case over. They proved their burden beyond a reasonable doubt. Just like that, ladies and gentlemen, just because of that credibility. Wow. Now, what was the second one? The windowsill. In his written statement and his statement, I guess, to the BCI agents, he said, yeah, he put the phone out like this, and he put the left elbow on the windowsill, and then he made an X. Okay. Well, geez, in court, he said, okay, well, I saw the left hand go down here and make an X. Where would your left elbow be, ladies and gentlemen? On the windowsill. He was right that he rolled it down. He was consistent about that. He was consistent about the X, consistent about showing, consistent about what he said, but somehow that's a huge difference. Now, I got to ask Mr. Scanlon those differences. Any of those two differences, would that change your opinion in any way, shape, or form regarding the use of force? Absolutely not. Mr. Scanlon looked at me like I had 3 heads or something. He's like, what are you talking about? That's desperate, ladies and gentlemen. That's desperate. Now, we did something in voir dire, ladies and gentlemen, where I showed you, life and death situation. Count how many times the person in the white t-shirts passed the ball. Most of you had the wrong numbers. Half of you didn't see the ground. Okay? Are you lying about that? No, absolutely not. Because the human eye trains on different things. Body-worn cameras don't interpret what the human eye sees. They don't interpret what the human eye perceives. Now, I'm going to put you in a life and death situation now. For 27 minutes, the time that Adam Coy was there today, I want you to write a 10-page statement. I want you to be interviewed for hours upon hours. I defy any of you to only have 2 minor inconsistencies. Ten pages. Pages of information, and those are the inconsistencies. You know why there's no inconsistencies? Because he was there and he told the truth. Truth isn't a coincidence. Consistency and cooperation are not coincidences, ladies and gentlemen. It's consistent because it's the truth of what happened. Test his credibility. Look at all these questions. He had the audacity to hand it to my client and go, find in there where you said, down on his right thigh. Find in there. Hours upon hours, questions and answers. That's what they found. That's what they're saying. It makes a person who an honorable discharge not credible, and he made up this lie. They want him to be superhuman. Compare him to Mr. 320 an hour. So he's gotten about 12 grand before, plus yesterday 8 hours, plus today 8 hours, plus travel back, plus the other times he got here. We're at about 20 grand. And he sits at home and reads all the material when he wants, when he's not tired, and he gets wrong that there's a knock at the inside of the garage door, then there's a knock out at that door. Never happened. Well, I don't know, is there a door there or not? He didn't know what the hell he was saying. He's got typos about whether or not he asked for that type of stuff. He has missing information. But that's okay for the government somehow. You can't have it both ways, ladies and gentlemen. I defy anyone to go through that situation and come back and say, yeah, this is what happened, and not have some minor inconsistencies. Are you gonna have major? No, because you were there and it's the truth about what you perceived. Seth Stoughton had that information for years in his report. Years, and never bothered to review it or never bothered to correct any of the mistakes. We're talking about corroboration, ladies and gentlemen, right? That's kind of the concept. Who corroborated Adam Coy's credibility? Amy Detweiler, on her perceptions and what happened. He announced gun, gun. He told me to stay back. That corroborates it. Now, another example, we talk in voir dire about physical evidence, ladies and gentlemen, okay? And again, on the video, the part that's on there, you can't really see what's in there. You can't. If someone says they can or can't, I'm sorry. You can't tell, all right? Now, let's look at other physical evidence. The coroner, all right? They call the coroner because they want to put all those pictures up there and stuff like that. What's the real aspect of the coroner here, all right? I don't know if you were, we'll go over it. Remember, I kept saying the wrong thing anatomically. It's anatomically correct, right? So, if bullet paths, anatomically correct, standing here like this, we know that the worst shot was right here. All shots were left to right, front to back, okay? Now, this is using your common sense, ladies and gentlemen. Can't tell the order, can't say how the position the body was in, but let's go through some, all right? Right here, left to right. That's a bullet path, okay? So if I'm standing this way, directly towards you guys, where must the bullet path be coming from? Over there. Who's over there? Detweiler. She doesn't shoot. All of them are left to right. The others on the leg. Left to right. Now, front to back. Some are upward, some are downward, depending on the position of the body. Okay, now, let's move it. What if, using your common sense, the person is bladed? What if the person is turned this way so that Amy Detweiler can't see the right hand? Where does that put the gun path, the bullet path coming from? Here. Who's there? Adam Coy. We know Adam Coy's shot. We know where he was. He was to the left of Amy Detweiler. Okay? So, does the physical evidence of the bullet paths through the body, left to right, front to back, make sense? If what you see on the video is coming out right here? No. Because that wasn't the angle that Adam saw. Because we know they had to come in this way. Front to back, left to right. Same with those. Again, standing like this, the bullet path has to be from there. Standing like this, the bullet path has to be from here. Standing like this, the bullet path has to be there. We know no one shot from there. Use your common sense, ladies and gentlemen. Corroboration, ladies and gentlemen, of his perceived threat. Corroboration of he perceived a deadly threat and acted, and where people were, and the positionings of the body. Body-worn cameras, ladies and gentlemen. Mr. Davis testified at length it's not what the eyes perceive. There's artificial lighting, the lens is different, it's a round lens, the positioning of the camera, that's why there's limitations. And he told you they don't normally match. What's on video doesn't normally match what an officer perceives and what an officer sees. That's why the limitations. But they want to rely on limitations. They want to rely on that. They don't want you to think about the bullet path and the position of the body and what Detweiler says. Just because something wasn't captured fully on the body-worn camera doesn't mean Adam didn't see it and perceive it. Video does not interpret what the eyes see. We all know the brain does. And you could be mistaken, as in this situation. Now, again, I've said this twice because there's a couple things you won't see in the jury instructions that's all Mr. Stoughton talked about. You won't see the word tactic in the jury instructions. You won't see it. And he was, that's not a good tactic. That's not a good tactic. That was an unreasonable tactic. You won't see it because it's not part of the analysis. You also won't see ability, opportunity, and intention as a definition of imminent threat because it doesn't belong there. He creates his own standard. Is it in Graham v. Connor? No. Is it in any others? No. It's not the law, and it won't be in your jury instructions. But even if you want to follow that down the rabbit hole, ladies and gentlemen, even if you do, more likely than not, break it down. Ability? Yeah, he had the ability. The distance and stuff there, Mr. Hill. Opportunity? Yeah. The opportunity to get a deadly weapon when he goes back to his car. And intention. Officers are trained, they don't even consider the intention of the suspect or the individual. You will not see anywhere in the jury instructions that you're to consider the intention of Mr. Hill, because it's not part of the analysis. And again, that's the hard thing to do. That's not a human thing to do, because we always say, well, what was the person's intent? What was their motive? What was this? What's behind the story? What's the real reason somebody did this? That doesn't come in this analysis, ladies and gentlemen. Now, let's look at the experts, just keeping it basic. Scanlon and Davis. Experienced? Beyond that. 37 years from one, 33 years from the other. Trained Columbus police officers and Ohio police officers? Absolutely. Scanlon trains all over the world. Practical? Yeah. Common sense? Yeah. Stoughton, how many times did Stoughton apologize? I'm sorry. I'm in academia. That's an academic term. That's an academia term. I'm sorry. That's the difference, ladies and gentlemen, that when you have real experience versus versus book versus theoretical academia, okay? Because he deals in a different world, think tanks, things of that nature. He doesn't deal with the everyday, day-to-day stuff. He was an auxiliary police officer for 6 months and an officer in Tallahassee, and patrol's the only thing he ever did. Look at the demeanor. Look at Mr. Scanlon, the awards he won. A national award, top 10 law enforcement officers in the country. And I said, and he went into, well, I saved someone who was going to commit suicide at the top of a cell tower. I was lucky. I was lucky to catch him. That's Jim Scanlon. Humble, this and that. Most people are up there, oh yeah, someone was up there, I went up there, I saved, I was a hero. No, not Jim Scanlon, because that's how he looks at things. Practical, basic, using your common sense. Two experts train law enforcement officers. Their expert trains law students. And this whole thing about being a lawyer, like, ladies and gentlemen, none of you are lawyers. We trust you to understand the jury instructions and to apply them to the facts that the judge gives you. And we know that. And we believe in it. Now, I can't get back up, but I don't even have to anticipate what they're arguing because he argued it. Killed for following orders for whatever reason, God knows what. I think we've put that to rest, so to speak, or dealt with that. If you're gonna lie about this whole thing, do you turn your body camera on? No. If you're gonna yell gun, 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 would you yell gun, gun, gun if you didn't believe there was a gun there? No, because then you gotta bring Amy Detweiler in as an accomplice, because she's gotta say it, and the positioning of the body, the same things, okay? But even so, let's follow this down the rabbit hole that it is, ladies and gentlemen. Let's go down there. Adam admits to being nice, that the guy was fine to him. If you were making this up before you turned the body-worn camera on and before you, after the shoot, would you say, man, that guy was so threatening to me. He told me in the car he was gonna kick my ass. Then when he went over here, he said, F you, copper. Wouldn't you do that if you were lying about that to make it more believable? No, Adam admits to everything. He wasn't doing anything wrong at first. That's why I went back to my car. Have a good night. Are you gonna make up something about, hey, have a good night? No, you would say, oh, then the son of a bitch did this, he did that. Use your common sense, ladies and gentlemen. That's how desperate it is. Oh, man. Luckily, there's keys there. Gee, I don't know. I train people at shoot, don't shoot. Adam Coy. What happens when you're through going to the course and you don't pass the shoot, don't shoot? You got to come back and do it again. You don't get a passing grade if you make a mistake. When you make a mistake in life, in his situation, you end up in that seat, ladies and gentlemen. He's a shooting firearms instructor. He's done it for years. He goes through the patterns. He does it. Oh, I'm going to make it up. Geez, I'm going to make it up. Oh, my God. So, of course, he teaches people about these situations. So, of course, he's going to, is it natural to say, I got to find what I missed. I got to find what I missed. After the shooting, he goes into shock. He's dry heaving. He just took the life of someone because he believed the person had a deadly weapon, a silver revolver in his hand. And they think he has the wits and wherewithal to go, now I got to make this up. Oh my God, there's some keys. There's the keys. There's the keys. There's the keys. Ladies and gentlemen, cooperation. Okay? I don't know what they're going to argue. I don't know if they're going to argue that, hey, we can't tell if the things were in the pockets. Okay, their expert says, oh, he had keys in his hands. Excuse me. So this one is Defendant's Exhibit 6, right? That's kind of a bigger view, right? And this is the government's. This one you'll have back there. Okay, oops, sorry. It's shot at a different angle, or I'm just showing you the depth, the two pictures. This one shows the actual all the way back there, right? But you see the cigarette there, and you see the cigarette there, right? Corroboration. I don't know if they're going to argue, well, we don't know if the cigarettes and stuff were in his pocket. Well, we do, using common sense. Why? Because when he came out to the edge of the car, he fell forward. The keys and stuff were there. The cigarette pack was there. There's no way a cigarette gets way back there. Obviously, he probably had the cigarette pack and the keys in his hand and his right hand when he came out. Okay? They didn't just fumble out of his clothing and stuff like that. I don't know if they're going to argue about that. That's ridiculous as well. Because the physical evidence shows. I don't know why the agent didn't pick up that cigarette. It's important because a pack of cigarettes is found out in front. So is it more likely than not that the keys were in his hand? Absolutely. Probably the cigarette thing too. But the packets of cigarettes, I'm sorry. Cooperation, ladies and gentlemen. I'm surprised they didn't say he planted the keys. Okay? I mean, seriously, under that type of theory, that he made all this up? Oh, by the way, I'll turn my body-worn camera on, and geez, man, I hope Titweiler didn't turn her body-worn camera on. I better get to her. I better go watch that so I can do my statement. It doesn't happen that way. Ladies and gentlemen, we have met our burden. We've proven to you that his subjective belief of imminent harm or death is in fact reasonable. We've proven to you, ladies and gentlemen, that he responded with reasonable force based on the shoes of a reasonable police officer in that situation experiencing that. And we've proven to you more likely than not, one smidge over 50%, that the mistake was reasonable, ladies and gentlemen. We have proven that to you. Ladies and gentlemen, it's not lost on us that someone lost a son, a father, a friend. Okay, ladies and gentlemen? This case is a tragic case. This case has affected two sides. It's affected that side forever, that man forever, this family forever. It's affected you guys forever. You will have this with you forever. And then at the same time, we ask you to set aside your emotions and empathy and to analyze this as a clinician. And I'm sorry that we do that to you, but that's our system. It's a tragic case. And ladies and gentlemen, the only tragedy that can be averted here is a second tragedy. And that's if you allow yourself to follow that argument that he lied and created all this stuff. Because that's simply not credible, and that would be a tragedy. There's only one verdict in this case, ladies and gentlemen, and that is our client is justified, we met our burden. You can't, you shouldn't, and you won't allow that to go down that rabbit hole and not use your common sense and be distracted. We ask you to return a verdict of not guilty. I thank you for your time. I thank you for your attention. I thank you for your emotion. And I thank you, wish you Godspeed in your deliberations. Thank you.
Thank you, Mr. Collins. Does anyone need a break at this point in time? Okay. Oh. Yeah.
Could I have one, Your Honor? And also a moment with Your Honor.
Okay. We're going to take about a 10-minute break, ladies and gentlemen, if we get you back in the jury room at 4:10. At 4:10. Okay, the admonitions that I've previously given you still apply. You're not to discuss the case with anyone or among yourselves. All rise for the jury.